Hello and welcome to our GDPR intro. In this presentation, we'll be covering the General Data Protection Regulation, which becomes effective from May 2018. Previously, data protection looked at exposure or vulnerabilities in the system and any threats that were possible. GDPR includes the addition of privacy of the data, which should be managed by a risk-based approach. So first of all, what is GDPR? So GDPR is a new EU regulation which is in place to protect people regarding the processing of their personal data and the movement of their data. GDPR regulations would not only be applicable to businesses inside the EU, but also those businesses outside the EU who are offering goods or services within the EU or monitoring EU subjects' behavior. So, for example, if a business based in China or the US is selling something on any EU market, they would also fall under these regulations. And we've included a link on this slide for the official GDPR regulations. So if you need to go there for reference, then the link is available for you here. Okay, so what is data? Data is the information which is processed, recorded, or held for any reason. This data would become GDPR data when a living individual can be clearly identified. And we'll be looking at a few examples of this in the next coming slides. So how to identify if data is personal data or not personal data? So personal data is anything where an individual can be clearly identified on the basis of the data. So let's take a look at a few examples here. So in the first example that we have, if we just have the name of John Woods, that would not be considered personal data because there are probably millions of John Woods in the entire world. So with just the name, we wouldn't know which John Woods we are actually talking about. However, if we add some additional information onto this, so let's say John Woods, Olympic gold winner from the country and the year, then that would be classified as personal data, as this would point exactly to which individual we are talking about. Another thing to take into consideration is where data is actually stored. So for example, if we have the name John Woods, which is being stored in a database which contains only names of all citizens of a large country, that would not be considered as personal data. As you can imagine, there probably would be quite a few John Woods that would come up there. However, if the database where we are holding the name or storing the name of John Woods was only containing local individuals living at a specific address or postcode or street name or residents of a small island, then that would be classified as personal data, as it would be easy to identify which John Woods we are looking for. Is data personal or not personal? The context of the data is key here. Let's take a look at email addresses, for example. The same would apply to telephone numbers. If we have a generic email address, for example, sales@example.com, that would not be considered as personal data, as it's very likely that the sales team or a group of people have access to this email. If there is a specific email address, for example, john@woods.com, that would be considered personal data, as it's associated with a particular individual, so we can more than likely assume that it's John Woods who owns this email address. However, if the email address john@woods.com is being used by, say, John and his family or John and his PA, then that would not be considered as personal data, as more than one person is using that email address. Reference numbers or identification numbers. So authentication cookies would be considered as personal data, as these are unique values which would be generated for a successful authentication on a user session, for example. Customer or client numbers would also be considered as personal data when it's stored with other personal data. So for example, if you have an Amazon order and you call through to get some information on your order, the first thing they will ask you for is your order number. And then along with this order number, the person on the other end of the phone would have all other information For example, your name, how the order was paid for, your address, the address where the order was being delivered to. If this order number has nothing linked with it on the Amazon side, then that would not be considered as personal data. So if they need to ask you for your order number and then ask you for other details regarding the order, so if they need to ask you for your personal data, then the order number would not be considered as personal data. Unique numbers to identify every employee in a given company would also be considered as personal data, as HR would have very detailed information regarding each and every employee. So if, for example, there is employee A001 and employee A002, it's very easy for someone to identify that these two people are different and get all the information on these two people. What should you do if there is a breach of GDPR data? So as soon as the personal data breach has occurred, the controller should notify the supervisory authority no later than 72 hours unless the controller is able to demonstrate that it's unlikely to result in a risk of the rights of the person in question. So basically you need to prepare, prevent, respond and inform if there is a data breach. In addition to this, we now also need to communicate with the data subject that there has been some kind of breach regarding their data. So there's been no time limit set for this, not strictly specified in the regulations, but it does say without undue delay. Let's take a look at the GDPR scope and the impact that it can have on your business. So it's most likely that all businesses hold personal data, and in some cases sensitive personal data, on all of their customers, clients, suppliers, employees, contact details, for example, any potential customers or mailing lists that you have. All of these would fall under the GDPR scope, and all of these would need to be considered for the GDPR regulation. GDPR privacy rights. There are 8 privacy rights under the new GDPR regulation. The first one of these is the right to be informed. So we are now obliged to provide fair processing information, which would typically be through a privacy note, so that the user is aware that their data will be processed. The second of these is the right to access the personal data. So the data subject has a right to access the personal data and any supplementary information that you have on them. The data subject also has the right to rectify if there is any inaccuracy or incomplete data that we have. Also, they have a right to be forgotten. So if there's no reason for the continued processing of the personal data, they can ask for this to be erased. They also have the right to restrict any processing. So they can request that the data is stored but not processed. Data portability, so they have the right to reuse their own personal data for their own purposes across different services, and they also have the right to object, for example, to profiling or direct marketing. Who is the data subject? The data subject is an identified or identifiable person, any EU citizen that has entrusted a controller with their personal data, for example, a customer or an employee, etc. The data subject must give their consent for processing of their personal data, and the data subject always has the right to withdraw their consent at any time. The data controller is responsible for and should be able to demonstrate compliance with the following 6 points. And the data should be processed lawfully, fairly and transparently. There should be some purpose limitations. So what that means is that the data must be collected for a specified, explicit and legitimate purpose. The data must not be further processed in a way that would be incomparable with those purposes. Data minimization, so limit the personal data collection, storage and usage. They must ensure that the data held is accurate. The storage of the data, so that should also be limited. The data shouldn't be retained for longer than is necessary in relation to the purpose that it was collected for. And also they must ensure the integrity and confidentiality of the data. The data processor is the person, public authority, agency, or any other body which is processing, so obtaining, recording, or holding the personal data on behalf of the data controller. The data processor could be carrying out an operation or set of operations on personal data, including organizing, adapting, or altering the data, retrieving, consulting, or using the information, making the information available via transmission or other means of distribution. GDPR guidelines suggest two data processing techniques, pseudonymization and anonymous information. Pseudonymization is replacing the data with artificial identifiers or pseudonyms, so giving the data an alias. This can be done using tokenization or reversible encryption, for example. Anonymous information means making the data completely anonymous, for example, hashing or using irreversible encryption. 3 questions to ask yourself are: is it possible to single out an individual? Is it possible to link records relating to an individual? And can information be inferred concerning an individual? If the answer to any of these questions is yes, then you need to revisit your data processing techniques. GDPR transparency involves the individual data subject and the organization. Any information must be concise, easily accessible, easy to understand with clear and plain language, including visualization if needed. It must be clear that the data is being collected, used, and to what extent the data will be processed. The individual must acknowledge the information and provide their consent. GDPR accountability falls on the data controller and the data processor. They must implement and demonstrate compliance by having policies and procedures, staff training and awareness, data protection impact assessments, and an appointed data protection officer in place. They must also notify the relevant authorities if there is any incident with the availability, confidentiality, or integrity of data. The Data Protection Officer, or DPO, is responsible for overseeing the data protection strategy and implementation to ensure compliance. The DPO would be the first point of contact for both the supervisory authorities and also the data subjects, and report internally to the Board of Directors. The first step for GDPR that should be completed before the 25th of May 2018 is a preparedness audit. Do you have the legal basis for processing the data? Do you actually have data that falls under GDPR? So, data discovery. If you do, where is this data? Are the data subjects informed of their rights? Do you have their consent? Establish the classification of the data held. Is it personal or not? Which protection measures will you use? How will you monitor the usage of the data? How long will you retain and how will you dispose of the data? Data Protection Impact Assessments, or DPIA, help to identify the most effective way to comply with data protection obligations. Data Protection Impact Assessments can be an integral part of taking a privacy by design approach, which is covered in another presentation on our website. You must carry out a DPIA when using new technologies and processing is likely to result in a high risk to the rights and freedoms of individuals. This could be systematic and extensive processing activities, including profiling or large-scale processing. The DPIA should contain a description of the processing operations and purposes, an assessment of the necessity of the processing, an assessment of the risk to individuals, and the measures in place to address the risk. In case of a suspected or confirmed data breach, you must be ready to identify and classify the events, analyze and confirm incidents, contain the breach, eradicate the root cause, notify the regulators within 72 hours, recover operations, and inform the data subject. As part of GDPR, you may need to implement a new set of required governance documentation, or alternatively review and update current documentation for GDPR compliance. These would include your data protection strategy, policies, procedures, guidance, and any benchmark configuration standards. Thank you for watching our GDPR presentation. For any more information or any consultancy, please do not hesitate to contact us. Thank you.